Hey y'all, how's it going? This is David with I'm So Offended. Um, I know it's been a minute, but I've been in trial for custody and it just finished. I had trial on Friday for custody. It's done. I'm waiting for the court ruling, but I think I did well. And once I get the hearing, I'm going to upload that and we'll discuss it. Um, what this is about, though, is just pointing out what petitions are because I don't think you guys understand sometimes like what it is you're filing or what it means to put a petition or to put a motion or what it means to be on offense or on defense and what you can and can't file. And I just did a video about being on defense for contempt. So first I'm going to say that this is not legal advice. I'm not an attorney. I don't practice law. And everything I say is for informational and educational purposes only. And I'm not liable for anything that you do. So, one second. So I just went to court to challenge legal decision making and parenting time, which is custody in a way, right? That's what it is. So there was no talk of child support, and it was my petition. I filed the petition, so therefore I get to choose what we talk about. I could have filed only for parenting time, but I filed for parenting time and for legal decision making. I filed to challenge those. Sorry about that. All right. So, again, and as I said in the other video that I just put up, the one of my videos with the lowest view count is probably one of the most important videos, and you guys don't realize that. But it's the motion in limine. Okay, because of the motion in limine, I was able to only talk about what was relevant, what was before the court. Child support wasn't before the court. It was my petition. I'm the one that filed. So therefore, I get to choose what we talk about. So when someone files a motion to the court, the person that filed it gets to choose what we talk about in court. If you're doing a simple motion to alter or amend a judgment, then that's all we're discussing, the things within that scope, within that rule. Just as I put up that video about the motion to alter or amend a judgment, and the other one about the motion for clarification, and then the other one for the Rule 85 motion, these videos. So when you're filing a motion to the court, if it's not in defense, if it's in offense, and you're the first one filing it, then that's the only thing that will be discussed. So if you file to challenge custody or legal decision making, that's the only thing that's supposed to be discussed. Now they can counter motion to introduce other stuff, and it's on you to shut it down. So I'm telling you, with the motion in limine that I've used 4 times now, I shut them down when it comes to child support. Each and every time. Each and every time. You guys don't get it, but that's like one of the most valuable things I have up on this channel. So I filed a petition. So this is what its definition is here. So a petition is a formal request that seeks a court order and states the reasons why it is needed. It could be filed by person, group, or organization, and is typically the first step in a lawsuit. A petition can also be used to appeal a court's decision. The First Amendment and the Bill of Rights protects the right to petition. Okay, so therefore, if you're filing when they're filing the rule to show cause, which is basically a lawsuit, they're petitioning the court. They're requesting a court order and state the reasons why it's needed. So what they're stating, like for instance, in the motion to enforce or in a contempt proceeding or in a rule to show cause, is that they're asking the court to punish you for not following the court order. What's the court order you're not following? Paying child support, right? So they want to punish you according to the rules of procedure for not following the order. But you can also be a petitioner. You are a petitioner if you file something against them. If you file a lawsuit, you're the petitioner. So you're asking the court to do something. You can't file a special appearance for a petition. You can't do that. You can't do that. There was a guy I spoke to that said he filed for a modification and then he said he filed a special appearance. You can't do that. You are literally asking the court for jurisdiction to preside and decide your modification, and then you're going to show up and say, I don't give you jurisdiction? That's stupid. Like it doesn't make sense. It's like saying, it's like you set an appointment with a doctor to go get seen, and you know, and you want to get checked for something. You think you have something wrong with you. You walk into the doctor's office and he asks for your name and you're all like, yeah, that's me. All right, what's going on? It's like, no, I don't give you consent. The fuck you mean you don't give me consent? You just made this doctor's appointment so I can check on you. What do you have? An injury? What's going on? Did you harm yourself? Are you sick? What? Nope, I don't give you consent. No. That's silly. That's exactly what you're doing if you file a petition for a modification and then you say, I don't give consent, and you file a special appearance. No, 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 no. Don't do that. You can't do that. You know what's going to happen? The judge is going to dismiss it and award the other party attorney's fees for wasting their time. All right? No. A special appearance is only filed in defense if somebody files an action against you. You cannot use it for custody, though. Custody is a constitutional act. It's the right to your children. So you can't say, oh, you don't have jurisdiction over me when it's about your kids. Now, child support isn't about the kids. We know that. So therefore, that jurisdiction can be challenged, right? But not when it comes to your kids, unless you want to terminate your parental rights. If you want to terminate your parental rights, you'll get there real quick by showing up with a special appearance to a custody hearing, you know? But no, that's not what it's used for. So when making a petition and writing one, here's some tips. There you go. Be clear. State what change you want to make. Make it realistic and concrete. Follow the rules. If there's a petition for such and such, look up the rules and it tells you what to put down. Be concise. Keep your message short and sweet. Include accurate information. Provide specific details or examples to support your claims. Include a call to action. Ask your target to take a concrete action. Like you got to specifically say what you're asking for. I had filed a motion to enforce, right? And under the rules 91 and 92, it states what the punishments are when somebody does not follow the court order. I had to file that because my baby mama doesn't comply with the order, and sometimes she doesn't want to produce my daughter, you know. So rather than pussyfoot around, I'll file a motion to enforce, and and have the judge force her to follow the order. And if she doesn't, then she could be sanctioned. She could be put on supervised visitation. She could have the kids taken from her, temporary orders. All kinds of stuff, even incarceration, because it's contempt. If the baby mama's committing a custodial interference and isn't producing your kid, it can lead to contempt. They can be incarcerated for that. Okay, so don't let the baby mama not let you see your kids. The first time she doesn't do it, make sure you get a police report. give her the opportunity and say, hey, you did not produce my daughter or son. Are you going to give me makeup time? Yes or no? And if she says no, or she keeps being, vindictive about it, then you file the motion to enforce. You use your text message as evidence. You use the police report as evidence, and you produce to the court that she's committing custodial interference, and you follow the rules. All right. Now it says create space for people to fill in their so personalize your petition. All right. So these are just regular, like a petition in general. It wasn't necessarily like a court petition, but these things, it's the same exact thing for court. So when filing a petition of what it is you want, look up the rules. It's going to say how the procedure is, how they need to be served. You need to show proof of service, which is an affidavit of service, right? Like I myself have served the baby mama's attorney, and I created my own affidavit of service. I went in there to drop the document off, and then in the affidavit of service, I put down the name of the document, the date already filled out. The only thing that needed to fill out was the time, because at that exact time, I don't know where I'm right there serving them, and then I put down a line for a signature and the name for whoever I'm serving. So I'll serve my baby mama, hers attorney's office. I don't serve the attorney. There's somebody there. He has somebody at his desk. And so I give them the paperwork, and I'm like, oh, can you sign this? They know what it is. It's service. So they sign it, and then I ask them for their name. Then I write their name down, and I write down the time. I make copies of that, and I go to the court, and I file it as an affidavit of service. And then I've just completed due process, right? Giving them the motion, having them served, so that way there is notice, and I'm giving them opportunity to be heard by giving them the motion, right? And then depending on if I filed and requested a hearing, then we're going to litigate, and we're going to go back and forth. And if I have a good faith claim, then we're going to litigate, and I'm either going to get what I want, or we're going to split the difference between their counterclaim. Okay, and that's how it goes. So a petition is you're asking the court to do something, okay? And you got to be specific, and you got to make sure you have everything, to support your claim. Have your attachments or whatever. Now you don't. It's not an evidentiary hearing unless it is, which is if you are requesting for an evidentiary hearing, or if you are requesting for a hearing, in order to appear, right, then you're having an evidentiary hearing. So then you have your evidence. You got to give it to the other side. You got to go to the courthouse, and you got to make sure that the court clerk has it, as far as, with the judge and their and their staff. And then you got to have your own copies, so that way you know what you're talking about and what you're presenting, and you set yourself up for success that way. And there's your petition, or there's your motion. Sometimes a motion doesn't need to be heard in court, and it's just paperwork. It's a paperwork motion. You file a motion, they file their response, and then you, as the petitioner, get to file a response to their response. And that's the way it goes. The petitioner gets 2 opportunities. Okay, the defense only gets 1. So that is the procedure. That is how it goes. Okay, if you file for a modification, you're giving the court jurisdiction in order to do something, and you're asking them to do something. All right. If you file a petition to change custody, for legal decision making, anything having to do with the kids, and you're filing the petition, you got to follow the rules of procedure. You got to serve them. You got to put in an affidavit of service. You got to, file your motions that go along with it. All right. This is not a special appearance kind of thing. No, you're asking the court for jurisdiction to decide on what you're asking them for. All right. Make sure you don't get that mixed up, because I was just tired of seeing guys contact me telling me that they're filing a special appearance for a petition they filed. You can't do that. And then they just fuck themselves. And I don't want you guys to do that. I'm here to help. I'm here to help. Okay? All right, that's why I return like every email I get. I want to let you know that some of the emails end up in my junk mail. I don't know why they go to my junk mail, but I'm checking my junk mails now, and I'm finding emails from you guys. So if for some reason you got lost in my junk mail and I don't respond, I usually respond within 2 to 3 days at least. But if you get nothing from me in 3 days, send another email. I periodically check my junk mail and it just might be in there. All right. So, I have no problem emailing you guys like for free. I have no problem doing it. I've even sent paperwork for free. I'm here to help. I'm here to help. But like if we got to get on a phone call or like a video call or something like that, I mean that's a very specific time and date that's going to take up my personal time. I would appreciate the donations because it does take up my time, and I have like a whole bunch of other things I need to do. But I'm here to help. So, anyways, that is it for this. And next video I'm going to put up is going to be my court hearing. That's going to be like in 3 or 4 parts because it was like 3 hours long. So, but yeah, you're gonna see me in action again. All right, y'all. Uh, share with your friends, share with as many men as you can. Guys, there's absolutely no benefit for a man to get married again. Please, if you've learned anything from all of this, do not get married ever, 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 ever again. It doesn't benefit you. It doesn't. Don't do it. All right. Peace.